when the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discuss separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. More and more use is being made in the courts of expert opinion evidence, and the question arises as to whether the expert can be asked to give an opinion on the very issue that the jury has to decide, and this is the so-called ultimate issue problem. But the panel also examines the problems of confrontation between one witness and another. Whether, for instance, a witness can be asked, "Are you saying that a prior witness is a liar?" or some such question. How far can you go in asserting the credibility of your own witness by attacking another witness?
A damage action. Doctor for the defense is testifying.
I did.
And doctor, you examined the plaintiff?
Yes.
Were there any objective symptoms of the plaintiff's alleged injury?
No.
All right, so I take it then that any diagnosis of the plaintiff would depend entirely what he says. Is that so?
That's right.
Now, doctor, can you tell us whether or not, in your opinion, the plaintiff is a malingerer?
Oh, Your Honor, I object to this question. Surely, this is asking the doctor to pass upon the very issue that the jury is here to determine.
This question raises, I think, several issues, and perhaps we could split them. The first basis upon which the objection was taken is that the witness couldn't testify because the answer sought dealt with the ultimate issue. So perhaps we can just deal with that one alone and then move on to the subsequent points. Professor Morton, what about this so-called ultimate issue rule? Can witnesses testify about the ultimate issue?
Well, my reaction to anything that's difficult, as is the question of can witnesses testify as to the ultimate issue, is to try to find some easier way of dealing with the problem. In other words, I would much sooner look at this question and say the counsel really is asking for trouble asking a question like that. He's going to get into a very difficult area of law, and really it would have been far better to ask a different question. It strikes me as really, it's the sort of question that would worry me, because the sort of question, no matter how it's answered, is going to provide a basis for appeal, probably. Far better to ask him whether or not the man's responses were consistent with his experience of treating people who subsequently turned out to have this particular condition in question, and leave the ultimate issue to be decided by the jury. In other words, rephrase the question properly. I think if I was forced to answer the question, is there a rule, I would say probably, provided the ultimate issue is just a matter of fact and does not contain legal elements, an expert witness may answer it. I don't think a witness could say this amounted in law to negligence. Yes. But he could say clearly there was a grave deficiency in the standard of care which was exercised.
Clay Powell. Well, we'll turn to Clay Powell, because I know that this point frequently arises in criminal trials where witnesses are asked.
He always asks them the question.
He always asks them whether or not the crime was committed and so forth. What do you think, Clay? Can a witness express an opinion on something which turns out to be the ultimate issue in dispute?
Well, it certainly is happening, and there seems to be ample authority for it. I think particularly of cases involving, let's suppose, a murder case, where everything is admitted save and except the question of intent, the capacity of the person to form the specific intent to commit the offense. It's not necessarily restricted to murder. It could be any issue like that. And the defense shrink is asked the questions. Rossick is an example, to my way of thinking, a judgment there. Lupien is another one, which seemed to be really almost the ultimate issue that had to be determined, that was being decided by the psychiatrist, which appears to be the trend today, that it's the psychiatrists in so many cases who are really giving the evidence in relation to the ultimate issue. So my answer is that there seems to be authority for it here now.
I'm just wondering, Mr. Powell, if perhaps you wouldn't agree with me that the issue is not really whether or not an opinion can be expressed on the ultimate issue, but whether or not the witness is competent to express that opinion. Is that perhaps the end of the problem to look at?
Yes,
Yeah, that in these Lupien cases and so on, you have someone who's competent to express an opinion on these psychiatric states of mind and so forth.
Yeah, I can think of lots of policemen who are pretty competent to express an opinion, too, if it goes right to that, you know. But we seem to accept psychiatrists' evidence today very broadly.
All right, well, let's go now to the next point. Not the next tape, but the next point in this one. Beyond being the ultimate issue in this case, or what's said to be the ultimate issue, the question as well is directed to credibility. The doctor is being asked, in a way, to express an opinion with respect to the credibility of his patient. Do you believe him when he complains of these symptoms? So I suppose the next issue then, apart from whether or not it's ultimate, can any one witness in a trial be invited to express an opinion on the credibility of any other witness? What do you think, Professor Morton?
Well, we could, of course, continue to talk about psychiatrists. I mean, psychiatrists, obviously, like God, can express opinions on anything. I mean, they're omnipotent in that regard. As far as an ordinary witness is concerned, again, I would counsel against asking a witness whether or not he believed another witness. It doesn't seem to add a great deal, and again brings you into an area of difficulty. I think Mr. Powell mentioned that he had a case in which He was, however, able to make use of the device of creating a confrontation between the accused who is giving evidence and the principal Crown witness, and I would be rather inclined to accept his point of view if I recall it.
Well, we'll get around to Mr. Powell. It would seem that, at least lately, as you know, and as doubtless the audience knows, recently in England, the House of Lords decided in Toohey that, at least within its own facts, a psychiatrist could testify with respect to the credibility of another. Do you think that that represents a beginning of some trend that we're going to have more and more witnesses commenting on other witnesses?
Well, I think we're going to move fairly rapidly to have to determine the admissibility of lie detector tests, of course, because that's the ultimate scientific test at the moment. I mean, probably a lie detector test would be held in better repute than an ordinary psychiatrist's opinion. And of course, we had that recently. Madame Van Camp had to face that issue here, and Filion. I don't know. I don't think we can get away from it, but at the moment, I would counsel people against pushing it. That's all I can say. It's an area of great difficulty and confusion.
All right. Mr. Powell, do you have anything to add on whether or not a witness can express his opinion with respect to the credibility of another?
Well, I appreciate that in the last lecture referred to Mark Adonis talking about Supreme Court of Canada looking down or commenting unfavorably upon counsel bringing about that type of confrontation, but it seems to me to be perfectly proper. Let's suppose in front of a jury, the accused is testifying and he is giving a story in direct conflict to that given by a major Crown witness. Now, it seems to me to be perfectly proper to suggest to him, or at least find out if his position is that that witness is a liar. I mean, that brings the issues out squarely. Then everybody knows where they stand, and the jury know what issue they have to determine. This is a straight confrontation. The other man is a liar. Now, apparently, there's a lot of people think that that's an improper thing, and if it is improper, then I have done the improper on many occasions, and I will refrain from so doing in the future if it's wrong. I just don't think it's wrong, and see nothing, no authority to prevent it, although I appreciate there's some comment and feeling. Your Lordship, would you stop me from doing that?
Yes. Well, I'd be interested in hearing what could be said further, but if I just might start off, it seems to me that in general terms, witnesses don't express opinions with respect to the credibility of others, except within the format of the old, formula. Do you know the reputation for truth and veracity in the community, and all that old hokum that seldom does anybody any good. The only exception that's gotten through in recent times has been the Toohey case in England, and if you don't recall it there, a witness was called simply to testify that one of the other witnesses who testified was mentally incompetent and therefore couldn't be believed, which seems to be an ultimately reasonable approach to the situation. Why shouldn't you know that one of the earlier witnesses was insane and couldn't be trusted? So the House of Lords in England said, fine, we'll take that type of evidence, and they decided that Gunwardine, the old classic case, was wrongly decided. So the door was opened, but it would seem only narrowly that you will take the evidence of experts to characterize the credibility of others, so that with respect to the ordinary folk, then, they can't classify others as liars. So in chief, at least, you couldn't hear this evidence. The defense couldn't call the accused and say, in chief, what do you think of Constable X? Do you think he's honest or not? And he could catalog all the Crown witnesses and comment on them. I don't think there's any court that would allow that type of thing. My question to Mr. Powell is, what makes it so admissible on cross-examination? Can you then ask the accused opinions that he couldn't possibly have given in chief? And can you say, having heard the evidence of Constable A, do you say he's a liar? Is Constable B a liar? And can you force him into a corner to now give opinions on cross-examination that he couldn't have given in chief. That's the difficulty I see with this thing, Mr. Powell.
I can't say more than I have, really. I just, to me, it seems to be proper issue to bring out on cross-examination. I'd like to refer to one case that is kind of interesting. It's not directly on point, but it's close. And it's a judgment of the Judicial Committee of the Privy Council in June of this year in a case by the name of Lowry, L-O-W-E-R-Y. It's a most interesting case because Lowry and another chap were charged in relation to a murder of a young girl down in Victoria in Australia. And the case for Lowry was, first of all, the case for the Crown was the two of them were acting in concert when they killed this girl. It was a terribly brutal murder. Lowry said, no, it was the other fellow that did it. So a psychologist for the defense of Lowry examined both accused and gave them a series of Rorschach tests and other tests. And then he was permitted to testify that having regard to the results of these tests he had carried out on the two of them, the evidence given by Lowry was more probably true. And the Judicial Committee of the Privy Council said that was quite proper evidence to be adduced. Now, that was brought out by evidence of Lowry's counsel, not by the Crown. But that shows how far, this sort of thing has gone. It's a most interesting judgment to read.
I agree, and it's sort of an extension of the TUI, that if you have an expert dealing with the credibility of one witness, the next logical step is to start dealing with the credibility of two and comparing them. Professor Morton, anything you want to add on this one?
Just to make it clear that when Mr. Powell asks the man if he thinks the police officer is a liar, he is not out to establish the credibility of the accused. I mean, he's asking it for a different purpose. He's not asking his opinion of the credibility of the police officer. He's ridiculing his opinion of the credibility of the police officer. He's trying to put him in an indefensible position, so he's engaged in a different tactic. He's not asking the court to disregard the evidence of the police officer because the accused says he's a liar, which is an entirely different thing. So he's not, I think some of this has to do with usurping the function of the court. And I think Powell would be on very safe ground in his example because he's really assisting the court by showing that there's a clear confrontation, that there's a clear distinction between the police officer and the accused, and that they have to choose one or the other.
I know, but do you really think that after all the Crown witnesses have testified as to one set of facts and the accused has testified to a contradictory set of facts, do you think it really crystallizes the issue to take the accused and force him to classify each Crown witness as a liar? I really don't think that it helps clarify any issue. It just forces the accused to give these silly opinions. There's a case in the English Court of Appeal, which I don't know whether it's in the material or not, in which there's a judgment by Lord Hewart in which he goes through all of this type of thing and suggests that not only is this improper, but all these other rhetorical devices where you say to the accused, do you ask the jury to believe, and so on and so forth. And his comment is that it's not the function of any witness to ask anybody to believe anything. It's simply for the court to assess and so on, that the witnesses are not to be asked all that type of thing.
So now we have the opening of the door in the last few years of bringing in psychiatric evidence on credibility, capacity, and on mens rea. So that we're saying to ourselves, what are the limits? Can they come in on the very issue of the case? It does look like perhaps they can when they're talking about capacity and credibility, about mens rea. But I'm very, very worried, and we'll see this probably in one of the latter questions if we get to it, but it does seem to me that psychiatric evidence is in a different class. Now, maybe that I know too many psychiatrists, and I see them at work and so on, but it was Lord Pierce, wasn't it, who wrote the judgment in TUI?
That's right.
And there he said, and you can see his logic, he said that if a man said he could see a certain thing at a certain distance, an ophthalmologist surely should be allowed to come in to say that he had defective vision. If he said he could hear, And surely an otologist should be allowed to come in and say that he couldn't hear. Now, if he says that he saw a thing, or he was a witness to a thing, surely the doctor shouldn't be kept in the wings. The psychiatrist should be allowed to come in. Now, what worries me about that situation is this. Knowing a little bit about the scientific instrumentation of otology and otology, you can't fool the doctors as to whether you can't hear or you can't see. They can talk with great scientific exactitude, can't they? But when a psychiatrist gets into the box and says that man is probably not telling the truth, is he not offending the character evidence rule? Must he not go further? And this is what I throw out to you for consideration. Must he not go further and say his capacity to observe or to recall or to narrate, which are the three essential criteria, aren't they, of any evidence, is impaired for these reasons? And shouldn't the court conduct a very careful inquiry to make certain? Because analogies limp. And I'm afraid, and I say it with the greatest respect to Toohey, that by taking a comparison of the otologist and comparing them to the psychiatrist, the court was probably jumping much too far and taking an exactitude in one that just doesn't exist.